I think the essays do two or three things wonderfully well. One, they engage what is not just an extremely relevant topic in terms of encryption, security threats, and also, it had a comparative requirement, right? So these are very, very important trends, themes, ideas to be able to think about, to be able to write. Why are they important, right? Well, they're important because today we live in a time, we live in a world where, in fact, the world of social media, the world of exchanging ideas, calls, thoughts, conversations through WhatsApp, Facebook, Signal, so on and so forth. The idea of data being not just knowledge, but being power, being currency, being perhaps the most valuable resource that exists today. This is a very different way of being for human beings, as opposed to, say, 10 years or 15 or 20 years ago, where it was still mines, lands, and tenders for spectrum. Right? So you are at a point in human evolution where knowledge about ourselves, how we think, what we aspire to do, who we like, who we disagree with, is actually power and currency. So this is, in fact, a major moment in how the law then has to keep up with changing human conduct as well as changing human technology. So we are also at a moment where commercial enterprise, companies like WhatsApp, Facebook, with their products, Instagram, or whether it's a variety of ways of being able to communicate with each other, these entities, these companies, in fact, are the biggest purveyors of not just knowledge, but they're also a regulator of conduct. In fact, Professor Jack Balkin calls them, they now are private bureaucracies, rightly so, because we expect them to regulate speech. But they're also extremely important because they have a global presence. They're governed by different standards all over the world. And coming to our own country in India, we are still a jurisdiction where we use an Information Technology Act, with its most recent amendment being the 2008 version, and the most recent rules for security practices and procedures being 2011. Now, in the last 15, 18 years, the world has changed as we know it. And what is, in fact, valuable resource is that wonderful thing which you can't actually, which is ambiguous, it's amorphous, it's data. And we're also in the world's largest constitutional democracy, which doesn't have a specific data protection regime or data protection law. And that is a unique position for any country to be in, to have such an invaluable commodity, data, and to have no statutory framework that actually protects data and holds folks liable when you misuse data. So you have Section 43A of the Information Technology Act 2008, which harnesses certain, a modicum of sanction on corporate bodies that misuse data, but equally so, the most recent introductions to data law in India, the most recent introduction to regulation, to encryption, whether it's of digital media, whether it's digital media entities, whether it's social intermediaries, as the information technology rules and amendments have brought in more recently, and of course, whether it's encryption laws, is it vests an enormous amount of power with the executive. So you have an invaluable resource that is not protected by a specific statute, and the vesting of the power to regulate, to intervene, is almost entirely with the executive. And I don't want to say state, because in fact, it is the executive. When it comes to encryption, it is, in terms of, emerging rules, it is the Home Secretary, which plays a distinct role, not the judiciary, when it comes to evaluating exercises where the state would like to intervene in encryption processes, whether that is encryption of, say, a good like WhatsApp, which has a higher encryption standard than governmental rules conceive of, or whether it's of, engaging and intervening in social media interfaces and companies, in what I exchange, conversation with my client, a written conversation, which I don't know if it's actually being intervened, whether that encryption is being broken. Obviously, this has manifold implications. This has implications on, for lawyers, on attorney-client privilege, as Mr. Tripathi will also speak to that. It has implications on work product, but it also has implications on constitutional values, freedom of speech, freedom of expression, the right to privacy. 9 judges in Puttaswamy speaking to a right to privacy. It has implication on global standards. Do we, in fact, conform to European standards? If our companies are going to do business in Europe, but these new regulations say that the state can, in fact, decrypt information, then what happens to these companies entering Europe, right? So now that brings me back to the essays. If this is the terrain, if this is the world that we live in, a new world, right? A new world where there are going to be private bureaucracies of corporations, in Jack Balkin's language, a new world in where private players will govern and will also engage in surveillance as expected by the government, right? So in Germany, you have laws where, in fact, private bodies, private companies like Facebook are expected to self-regulate in terms of hate speech, and there is sanction if you don't, right? If you don't take down fake news. So you have a emerging global regulatory framework where private players play an extraordinary role. And we can go into whether that role is sufficient, whether they should have more protection or less protection. But you also have the executive in the world's largest constitutional democracy intervening and playing an unprecedented role, often in contravention to expectations of constitutional values, where the judiciary is expected to look at warrants if you'd like to seize goods, where that, in fact, is set aside and exceptions are created when you want to decrypt data. So that is the world we live in. Now, the bits I really appreciated about the essays, and there were varying degrees of ideas that they engaged, is that they all engaged statutory law, domestic statutory law, in an extraordinarily rigorous manner, right? And I thought that was wonderful. Where I would have expected a little more is the comparative assessment, right? When you're thinking about India, you're thinking about China, you're thinking about the United States, you want to be able to make that comparative assessment, because the US regime of not just data protection, but encryption, which is often specific to function, which is specific to the agency in question, is very different from the European expectation, is very different from the Indian, frankly, lack of any expectation of protection, privacy, decryption protection, right? So you want that to be kind of explored in a more, I would say, rigorous manner. One of the disciplines that I think about and I work in quite often is comparative constitutional law, where we compare constitutional regimes. So say, India, how does India safeguard, say, speech as compared to Brazil, South Africa, US, UK? And comparative analysis has its own method. It's extremely rigorous and has great value, because it actually speaks to best practices and worst practices. So I would have hoped for more of the essays, a couple of them do, but I would have hoped for more of these essays to, in fact, have engaged comparative jurisdictional differences, similarities, challenges, and best practices more closely, right? And obviously, the kind of, the cybersecurity threat that, say, China poses to India or frankly to the world, I think you need to be able to engage that jurisdiction closely. Today, if you are interested in the world and you do not engage the dragon, then you are, in fact, leaving out a major challenge, a major success story, but also a major threat to many constitutional democracies. So I think we have to be able to explore, appreciate, understand, analyze China more closely, especially when it comes to issues of the internet.